counsel's firm got a public interest appeal granted to hear an appeal of that order before the Supreme Court. As we sit here right now, that order hasn't been stayed by any court. That order is still in effect. And I would be remiss in not drawing Your Honor's attention to a statement that the defendant made to a Greek blog on September 24th, where he commented on Jennifer Dulos' mental health in direct contradiction to your order. I don't know what the court intends to do with that regard, but I wanted to bring it to your attention. As the order was very clear, it did cover the parties. The defendant's comments were absolutely in contradiction to your order.
I'm not familiar with the exact words the defendant used, but I did note that Attorney Pattis said that not all speech was barred. Counsel, you wish to respond?
Yes, Your Honor. We don't believe that this speech was barred. The sum and substance of the statement, such as it was simply that he had known of Ms. Dulos' mental illness early in their marriage and that he loved her nonetheless. First off, the letter of the order talks about parties, victims, and witnesses. We don't believe that that would apply to Jennifer Dulos, given that there is no murder charge here, though that is often the assumption that is made, is that it is somehow the Phantom and the Opera behind the scenes controlling things. So there is our position as to the statement itself doesn't fall under the order, and additionally, those questions were sent, as I understand it, in written form. They were reviewed by counsel. Certain questions, in fact, were not answered because they perhaps could have violated the order, which we have filed a public interest appeal about. And then the answers that were provided were done under counsel's advice based on the understanding of the order. So we don't think that it violates the order.
It's your order.
Well, first of all, I'm glad you brought the order up because you did write in your appellate brief, counsel, that the court's order regarding the restrictions was issued without a hearing. In fact, that was not accurate because we had a hearing on that very issue. I gave you permission to file a supplemental brief, but to state that I issued that order without a hearing is not accurate. Also, the order, which is attached to my memorandum of decision of September 12th, is binding upon the defendant and his immediate family and associates, and there are exceptions found on page 3 of the order, and I don't see how the statements about his missing estranged wife's mental status fall within one of the exceptions. Here's the issue. I know this is now on appeal with the Supreme Court, but it has not been stayed by that court, and until or unless they do either vacate my order or modify that order is in effect, and the court will defer any ruling or decision on what the state is bringing to my attention until we hear from the Supreme Court. But I would urge you, sir, to understand that the order remains binding unless it is modified or vacated by our Supreme Court, and to conduct yourself accordingly.
Now, the matter at hand today, Your Honor, is the counsel's motion to dismiss the charges against Mr. Dulos. I would just ask, Your Honor, to look at our brief. The case law is very clear in Connecticut. And before we get into this, Your Honor, last time the case was in, Attorney Pattis did agree to waive any right to object to you hearing this motion with regard to the motion to dismiss because you signed the warrant in this case. I just want to make sure that Attorney Smith is actually also agreeing with that. I don't want to have to deal with this issue later on in another proceeding and say it wasn't addressed.
Your Honor, I of course stand by that. Attorney Pattis and I work hand in hand, and so any representation that he made, I'm happy to honor.
All right. No,
so then just along those lines, Your Honor, the arrests we're talking about were effectuated by an arrest warrant. Looking at the case law, motions to dismiss can't be granted in those situations. So I'd ask you to deny counsel's motion. I would reserve any other argument that I have till after he's done. Because I don't know what he's going to say. It's a pretty black letter.
It is his motion. I will let counsel be heard. And again, your colleague is fond of referencing the public interest in this case, but as you well know, this is a narrow issue of law, and this is not the time for closing arguments or summations, but if you would address yourself to the narrow issues of law that your motion raises under the practice book sections you cite, I appreciate it. Thank you.
Yes, Your Honor, of course. I sense there is a fear that I'm going to do something untoward, and I hope that I can allay those fears. Our argument here is very simple and very discreet. The state is right to point out that under certain circumstances where there has been an arrest by warrant, certain challenges cannot be made. However, the provisions under which we have made this motion do allow us to do so. Much has been made by the state as well in its brief in response to ours that we simply can't make this because what we've done is gussy up an evidentiary claim and bring it in under a different name, and such it remains a pig nonetheless, no matter how much lipstick we might put on it. But I think that the state's argument is belied by case law they cite in their own brief, which says an information is construed liberally in favor of the state and is only invalid if it is so obviously defective that by no reasonable construction can it be said to charge the offense for which the conviction was had, or in this case, in which the conviction might be had. There is no construction, liberal or otherwise, that could sustain this information, because what this information charges is a hindering charge that requires some other felony, and that is what is not present here. The notice it gives is thus defective. It names the offense, true, but it cannot be said to charge the offense because it does not name what the predicate felony is. That is as to the hindering charge. And it is clear, we think, and it is obvious, and I will concede that the state and I both have very different views of how that is to be interpreted. But that is our interpretation, and we believe the only fair one. The state elects not to address our unconstitutional claim, and they do that, ducking it entirely and claiming that's because it's inadequately briefed, and so the appellate court would say, no way, you don't get to make this argument here. But we're here at the trial court, and perhaps that criticism is well placed. Nonetheless, the trial court can take a look at this, ought to take a look at this, if this is the stitch in time that might save us 9 or many more. The law is unconstitutional as applied in this instance when it comes to the tampering charge, because there simply is no notice that this type of conduct, even if you take it and view it in the light most favorable to the state,
Which I have to.
which you have to, Your Honor, but there simply is no notice that this conduct, that doing something where there has been no investigation instituted, no proceedings which were in the offing, there is no notice. If there were some notice, and that's required under the statute, then perhaps this could lie. But we think that this is an instance where the state has no clothes on. It's telling you it's got these things, and simply because it has charged them and created what we think is more of an investigative detention situation while they hope to get evidence of other charges, it is nonetheless an instance where they don't have what they claim to have. There is no tampering that in this instance could lie because of the requirement under the statute that there be a belief that a criminal investigation conducted by a law enforcement agency is pending or about to be instituted. That simply is not the case here, Your Honor. And I recognize that you may not address that question. Nonetheless, we have raised it, we believe, enough for this court to consider it, and for another court now that we have this record to address at the time necessary. It's at least been preserved.
Thank you. State?
Informations are to do one important thing, inform the defendant of the charges against him. There is no requirement that we have to allege predicate offense in an information. There isn't one. It has to set out charge, the statutory or section of the statute that the defendant is facing, location and general date of the offense, and that is done in this instance. So his claim should fail there.
Was there a defense motion for a bill of particulars here?
No.
Not at this stage, Your Honor. As far as that goes, we think that the motion to dismiss, given that it would be a jurisdictional issue, ought to be decided prior to any requirement to have to file a motion for bill of particulars.
And I don't know how I could get to the constitutional issue. Counsel didn't raise any issues in his brief. Gloss on it here. I don't even know where to go with that, Your Honor. The offense is the offense. He's charged with the charges he's charged with. Judge found probable cause for them. The practice book section and the statutes are very clear. When a warrant issues, these motions to dismiss should fail. So you should deny his motion.
Counsel, your brief does not really analyze the constitutional claim under the practice book section 41(8) subsection 8, does it?
Your Honor, as I said before, it is perhaps a well-placed criticism that this is not as fully briefed as we might have liked. Nonetheless, it's now been raised. Here we are. And I think that the state has perhaps tacitly conceded that they have no clothes on. The offense is the offense. He is charged with what he is charged with. I would agree with that if there were one clause, something separating those two clauses. The offense is the offense, and he is nonetheless charged with what he is charged with. There is a difference between simply saying, well, we have said the magic words, and actually having something behind that. There is nothing behind it here. They have simply said it. They have said there is hindering. And yet to say, what notice do we have of the predicate charge that would be required for hindering? We don't have it.
Don't need it, number one. Number two, again, constitutionally, right, these claims fail because there was a judge that found probable cause in these instances. I don't know why we are wasting time here. If he's saying that the statute is unconstitutional because it's vague, then argue that, brief it, and say it. But he's not saying that. He's trying to have you dismiss these cases when a warrant was signed when there's no reason to, or legal argument to. We could go back and forth with hyperbole all we want. There was a warrant issued in this case. His motion to dismiss should be denied. Thank you.
Well, as I read the practice book, section 41(8) subsection 2, the motion to dismiss is properly considered as against the information itself, not the warrant affidavit. And in this case, there is what's known as a short form information, which does not allege any specific, but merely a statute allegedly violated and the statutory subsection. That's the state of the record. But I've considered the arguments of counsel. I will take it under advisement. We need to have another date for further proceedings. I know there's some ongoing discovery issues and other things.
We spoke with counsel, Your Honor. I did provide him with a lot of discovery. This morning, he actually provided us with a 2 terabyte drive that we're efforting copying additional information on for him right now. We discussed November 6th as the next court date.
That is correct, Your Honor.
All right, and I did, for the record, I did receive an updated report from judicial that the defendant has been compliant with his GPS since the last court date, and so the court is gratified to learn that. So we will see each other in November then. Any further business to come before the court?
Nothing from the defense, Your Honor.
We'll stand adjourned.
All rise. This Honorable Superior Court is now adjourned. Grab your belongings and exit the courtroom.